Just waiting for Facebook to load up. Hi, everybody on Facebook. This is Elektra Yao, artist visa lawyer. And today we're going to talk about the big elephant in the room, something that I hope not a lot of people have experienced, but it does happen sometimes. We're going to talk about what happens if you get an RFE on your O-1 visa. Now, RFEs are a little bit difficult to process because it means that there's a delay in your case, number one, and it also means that the government is asking for additional information to prove the merits of your case, to prove the criteria that you initially argued in the underlying petition. So it's always very stressful to gather more information and also to kind of just tell your future jobs like, hey, I've got to, answer this before I'm approved and before I can start working. So you prepped your petition, you worked with an attorney, and you got an RFE, and now you're kind of freaking out. You don't really know what to do. So first things first, the thing that I always suggest is if you filed pro se, if you filed without an attorney, the best thing that you can do for yourself and for your O-1 petition is to go and have a consultation or a strategy session or a meeting with an experienced attorney that has experience working with O-1 visas and artists in general. Immigration law is quite complex. There's lots of different facets of immigration law. There's removal defense, there's deportation defense, there's family-based immigration, there's humanitarian immigration, and there's employment-based immigration. So maybe if you go to an attorney that specializes in deportation defense or removal defense, you might not have the sort of experience that you want to really try to strengthen your case. So it's really important that you meet with an experienced attorney that works in particular with O-1 petitions, P petitions, EB1s, etc. After you've had your meeting with the attorney and you've kind of figured out what are the issues with your case, you need to start working on them. But let's first backtrack. What are some potential issues that you will notice within an RFE? So one thing that you can notice, and this is something that we see all the time, is you can notice a misapplication of the law. Sometimes USCIS will broaden the scope of what the law is or be very, very strict in what the law is. So let me give you an example. Sometimes USCIS will interpret critical role to be lead role, and that's not the law. There's two criteria. We call this the twin criteria. One part of the twin is lead and starring, and the other part is critical. So you don't necessarily need to prove that you're serving in a lead role for both of those criteria. It's only one of the criteria that ask for a lead or starring role. So if you see misapplications of the law in the sense of the laws being super broad or like very, very closed and abridging and changing the meaning of the law, these are things that your attorney can overcome through legal arguments by citing the law, by citing case law, etc. If there's, for example, a deficiency in one of the documents that was submitted, so let's say, for example, you submitted a deal memo and the deal memo doesn't include how much money you're going to earn for the project, this is something that can be corrected by redrafting a clarification letter. We call this employment clarification letters within my firm to really speak to the issue that USCIS is having. And sometimes you can be really unlucky, maybe work with an inexperienced officer who kind of just ignores all the contents within the petition and then just regurgitates a boilerplate RFE, which requires you and the attorney to essentially re-argue the case. So the first thing you're going to do if you receive an RFE, the first thing you're going to do is you're going to go and speak with a licensed attorney that has experience with O-1 petitions and working with artists. The second thing that you're going to do is you're going to talk with your attorney and assess what the issues are within the petition. Is it a misapplication of the law? Is it a deficiency in one of the documents submitted? Or is it just simple clarification and additional evidence needs to be submitted, right? Additional evidence can be anything from an additional testimonial letter to, for example, other types of evidence to actually prove that you've done what you've done. Once that has been addressed, then the documents actually need to be drafted. They actually need to be created. So the attorney needs to analyze what's going on within the RFE to draft the appropriate documents. Now, I want to backtrack for a quick second. Let's say after the meeting with with the attorney, you've kind of not feeling very confident. You should know that you have a couple of options when it comes to the RFE. The first option is you can fight it, right? So you can go through the whole strategy session, gathering the documents, gathering all the information that you need to focus on the case. The second thing that you can do is you can withdraw the case, right? You can actually withdraw that petition and then start a whole new petition. Of course, you're going to lose filing fees because you're refiling the case again, but sometimes that might actually be the better option if the RFE is very difficult to fight, in the sense that you can tell from the tone of the petition, from the language utilized in the petition, that the officer has no intention of approving the case. So again, it's not that you are forced to answer the RFE notice. You don't necessarily need to answer it. You can withdraw the case and refile it again, addressing the deficiencies or addressing the issues that were pointed out in the original, in the RFE notice. But again, let's just backtrack and recap. So once you get the RFE, what can you do? You can withdraw that case and refile it, or you can fight the RFE. If you've decided to fight the RFE, you must go speak with a licensed attorney that is experienced with O-1s. Number two, after you've spoken with the attorney, you and the attorney need to identify what are the issues within the RFE. It can be a deficiency in the document submitted, it can be additional evidence that's required, or it can be a very complex issue such as the misapplication of the law, or the abridging of the law, or actually changing of the law, or applying laws from other types of visas onto the O-1 visa. Then you have to actually start to create the documents that address those deficiencies. Now, these can be clarification letters or employment clarification letters. It can be additional testimonial letters. These can be confirmation letters. These can be affidavits. These can be all different types of documents that address the issues within the case. Now, do you need to re-argue the whole case? No, I mean, it really depends. It really depends what's in the RFE. But a good rule of thumb is to definitely address all the points that they have made within the issue, within the case. So, for example, let's say you submitted 5 forms of evidence, right, or like 5 projects, and they only talk about 2. You're definitely going to want to address the 2 projects where they found deficiencies, and you're going to want to bring to their attention that they did not talk about those additional 3 projects. Does that mean that those additional 3 projects were accepted? And if they were accepted, why was this RFE issued for those 2 projects that they didn't accept? So these are legal strategic questions and answers that you will develop with the attorney. But you should definitely address all the points within the RFE notice, because otherwise you're not really satisfying the request, which can be the basis of a denial. So even if you don't have additional evidence to address the issues that they've brought up, you want to re-argue the issue, the evidence and the things that you argued in the original underlying petition. So even if they found issue with, let's say, Cinderella production, and they want more evidence, but you don't have more evidence, you should definitely point out to them the evidence that you previously submitted in the underlying O-1 petition, and point out that they should accept it. And if they don't give a reason why they're not accepting it, then that's contrary to the law. Again, these are things that will be developed with the attorney. It's really important that you follow it, and it's really important that you take RFE seriously, because a denial of your O-1 petition will be on your record for 7 years. Now, is a denial something that prevents you from refiling your case? Absolutely not. You can be denied today, refile tomorrow, and get approved. The only thing is they have the ability to look back at your procedural history and see that you were previously denied. But I can tell you in my experience that I've worked with many people who've been previously denied with other attorneys, and it is not something that is a barrier to them getting approved for the O-1 or for the EB-1A should they eventually qualify for it. So RFEs happen. It's a part of the process. I think that USCIS has definitely a quota that they need to meet. So in our firm, they don't happen often, but they do happen. We really try to get the cases approved very, very quickly because we understand how important your career is. I invite you guys to go look at our 2 newest reviews. We're very happy for our clients who have been approved and to be able to continue their work and their livelihood here in the US. But if it does happen, you can definitely get the case approved if you utilize sound strategy and you really understand the nuances of the tone of the officer and you really address all of the issues that have been identified within the RFE. And if you include stuff within your petition and they don't talk about it, have them recognize it, bring that up. I mean, understanding the tone is very important because I think that lends itself to understanding the strategy that you want to use. If you're going to be aggressive, if you're going to be subservient, all of that is, these are strategic decisions that the attorney will make. So just to recap, if you get an RFE, you can fight it, or you can withdraw the petition and then refile a new case. If you decide to fight the RFE, then you need to have a meeting. After you go to the meeting, you need to identify what the issues are with the petition. If you have an issue, once you've identified the issues within the petition, you need to create the appropriate documents that address those issues, and you need to address all the issues within the petition. I hope that this was clear. I hope that this will help you on your O-1 journey. If you have received an RFE or if you have received a recent denial, please reach out to our law firm. We'd be happy to help and look over your documents to help you on your path to being O-1 approved so that you can work within the US and earn your livelihood as an artist here in the US or in New York City, the Big Apple, the city of the arts. So I will be back tomorrow to talk more about the O-1 and RFEs and green cards. Again, thank you so much for watching, and I will see you tomorrow. Bye-bye.